Good evening, everybody, and welcome to today's show of Property Focus. Now, today we're looking at some of these uncontrolled developments that are just taking shape in these neighborhoods. Now, you've heard of them, you've seen them. Your next door plot wants to probably erect about 17 floors. How do you stop them? What are the ways about going about this? We're going to be talking to some authorities in this space with the CARA and NCA to just demystify and get to know how to just stop some of these uncontrolled, unscrupulous developers from putting up these skyscrapers in controlled neighborhoods. My name is Peter Ngigi and welcome to Property Focus. Briefly introduce yourself.
My name is Henry Chen. I'm the CEO of CARA, that's the Kenya Alliance of Resident Associations, which is the umbrella body of neighborhood organizations that looks at issue of service delivery. We look at how to organize communities at the neighborhood level to be able to engage on aspect of public participation and structured engagement of government on the area of service delivery. So as CARA, we've been around for the last 20 years, and we talk about mobilizing and supporting communities to understand their roles and responsibility, but most importantly, to understand how they can be able to contribute to the well-being of the society and, of course, their neighborhood. So we have members across the country, and we support them through capacity building, through information sharing, and also giving them the right environment to be able to thrive and be able to contribute to the well-being of their neighborhoods. Yes.
Now, when it comes to developers who want to break the stipulated heights that have been given and approved, how can the association step in and counter this?
Now, when we talk about uncontrolled development, it's mainly issue about planning. And planning starts with the developer, first of all, explaining or indicating what they want to achieve or what they want to do. And planning also have the component of community engagement. So some of the challenges we face today is because in the process of undertaking planning, we have unscrupulous developers who want to take shortcuts. We have very clear laws on what needs to be done in terms of when you want to come up with a development. For instance, if you want to put up a structure in a particular area, the first thing you need to do is to get a planning approval license from the county government. You also need to get an environmental impact assessment license from NEMA. And of course, if you are building in a riparian area, you need to get like approval from Water Resource Authority and many other regulators who exist. So all these processes and all these entities have a component of public participation. And public participation in the sense that before you even make an application to the county government, for instance, or about your development, you must be able to inform the primary people who are going to be directly affected by that development. You must be able to share with them the plan, you must be able to indicate to them what you want to do and have a contribution from them. So what happens is that, for instance, if you want to come up with a structure in a particular area, you have to go through the EIA process, the Environmental Impact Assessment process. And this is a process that is overseen by NEMA. Within this process, you must be able to have an opportunity to be able to engage communities in that area and tell them what exactly we are putting up, the environmental impact of this development, and how you are going to mitigate any negative impact, for instance. The population or the community that within that area have a right and opportunity to give their views and say, we agree or we accept this development or we don't accept it, and give their reasons. NEMA has a responsibility to be able to consider the issues that have been raised by the communities in giving their license. If the issues that have been raised by the community are strong and valid, then NEMA must be able to get back to the developer and stop that development, or give a license with conditions. Tell them that for you to proceed with this process, you must be able to do 1, 2, 3 in terms of mitigation measures. The same case with the county government, because before the county government gives the approval license, they must be able to confirm that the communities in that particular neighborhood have been given an opportunity to also have a say, and they have to have the comments and issues raised by the community as far as the development is concerned. So all these processes are actually supposed to be followed to the letter when coming up with that development. And we have a mechanism that can be taken when the community feel that their issues have not been addressed.
So what are some of the procedures that you can follow as an association? So there's a development that's coming up. What are the procedures to follow?
The best way, most of this is done through established resident associations, because they are the primary beneficiary, or the people will be affected by that particular issue. So they can be able to file an application with the net directly. And what happens is that as CARA, the role we can be able to play is that because these are our members, we can come in as interested parties, because we can't go directly and lodge an application on behalf of the association. They have to do it, and then now we come on board as interested parties to also give our views and give weight to the whole application. Once they now go to court or to the tribunal, then CARA can come in as an interested party and also give our views on that. Same case with the process that is managed by the county government. Because what happens in that aspect now is that when a license is issued by a county government and there's an objection to it, then the community or whoever is objecting can be able to lodge an application with the county planning and land use committee that has been put in place by the Planning and Land Use Act, so that can be dispensed with at that particular level. If there's a problem, then you go to the next level of environment and land court, and then it follows the procedure. But I think what I need to say ultimately is that the legal process is quite tedious and of course requires a lot of resources. Mostly what needs to happen is, number one, is for resident associations and people within a particular neighborhood to first of all understand the laws and regulations that govern development. There's something called the zoning regulations that provide very clearly on what kind of structures and what kind of development that are supposed to be taken up in a particular area. So once you understand what the regulations for your neighborhood are, then the next thing is for you to be able to be very vigilant and take an interest on whatever kind of development that is taking place in your area, so that if you see something that is out of place, that does not meet the zoning regulations, for instance, then you need to raise an alarm early enough so that it can be stopped and the issue can be addressed effectively. So as CARA, we encourage our members, and we do a lot of information and education on a number of aspects about zoning regulations, about the laws that support development, and we encourage our members to be able to ensure that they can be able to identify this kind of mischief early enough and be able to raise an objection and raise a concern before it is too late, so that we stop it before it goes to a level where we now have to go to court.
How can our viewers get to reach you? But before even we get to that, what is advice that you'd like to give our viewers as to opposing some of these developments?
What I would like to say is that CARA is the umbrella body of resident associations, and we exist to be able to organize these communities to have the right information and the right capacity to also play a role in the whole thing about service delivery. Our constitution is very rich when it comes to public participation, but public participation requires that the communities are also organized. When you organize yourself as communities in form of resident associations, then you can be able to engage in a structured and effective public participation. So what we are saying is that for you to protect your neighborhood, for you to be in a position where you are on top of things as far as what happens in your neighborhood is concerned, you must first of all organize yourself into resident association. Number two, you must support the resident association to be able to achieve its mandate. But most importantly, you must be able to really get a lot of information that will enable you to identify where there's a problem, enable you to understand what to do when there's an issue, and also enable you to be able to be part of the process of effective service delivery. I think that where we need to go to right now as a country when it comes to this kind of issues is to take advantage of the digital platform, or ICT for that matter. If, for instance, we have a situation where the county government or NEMA are working hand in hand with resident associations to provide an effective mechanism of sharing information, so that if there's a problem in a particular corner, then it is very easy for me as somebody who lives in that particular neighborhood to pass that information and it is acted on. I think that will address half of the problem. As Kara, one of the things that we've done is that we've created what we call Hatua platform. This is basically a digital platform where we enable our members to share complaints or share information about issues within their neighborhood. So NEMA, the county government, the National Construction Authority, and all these agencies must be able to apply the law effectively, but also coordinate their work, because one of the challenges we have is lack of coordination among these agencies.
Brilliant. Well, thank you for coming on to Property Focus, Henry.
Asante sana.
Now, if you have a challenge with any developer who's putting up a project and it's unscrupulously tall and it just breaks the zoning regulations, you know where to go. This is Property Focus. We're going to take a short commercial break, but when we're back, we're going to have a chat with the CEO of National Construction Authority in just a moment. Stay tuned. Welcome back from the commercial break. Now, you just heard from the CEO of Kara. Joined with me, we have the CEO of the NCA, Maurice Akech, to tell us a little bit more about what you need to know about uncontrolled developments. Welcome to Property Focus.
Thank you very much, and welcome once again to this very exciting interview, which is very informative to the public for purposes of getting information, knowledge, and also awareness, so that at least they're able to do the right thing at the right time in the right place.
Now, interesting. What is an uncontrolled development? That's what we're looking at with this particular episode.
You have certain parcels of land where you could have people who are occupying and they have no what we call legal status of ownership, and they go ahead and build on this kind of land. This particular one is uncontrolled because there is no way you can control an inhabitant who is occupying land that's not belong to them. So basically, that would mean that they're just building haphazardly, because in any case, they have no ownership of that land. The other aspect of it, of uncontrolled development, is one where, yes, the land belongs to you, but you decide to go ahead and the land is belonging to you, and also is recognized as part of the development plan in that particular area. But you go ahead and put up something in terms of development, either a residential house or commercial property, but this particular development is not in compliance or in tandem with the development plans of that area or the zoning areas. That means it's not controlled. You are doing something outside the plans of that area. So in a nutshell, it's also a plan that has not received the necessary approvals from the approving authorities, which in this case, the primary approving authority for any development in this country, as per the Physical and Land Use Planning Act 2019, is the county. Then from there, it moves on to other players who are also the regulators in the construction sector, including the Environmental Authority, NCA, as well as other players in the sector. So uncontrolled development is development that has no necessary approval, that has received blessings from the approving authority to be able to put that development in that place.
What requirements do you need to comply with the NCA when you're putting up a development in the first place?
For a fully compliant development to take place, and this is more so development in the housing sector, to construct a building. One, you are required to seek development permit or permission to develop from the county for which your parcel of land belongs. Okay. For instance, if you're in Nairobi and you want to do development in Nairobi, the first thing is to prepare those plans by a competent professional, in this case, the architect, who prepares these plans, and they are submitted to Nairobi County for purposes of approval. And this is applicable to all other 46 counties across the country, apart from Nairobi. Including Nairobi. Then, upon getting that approval, it's very important to note that there's also a requirement to get structural approval, because plans will just show the size of the development, the kind of development you want to do, the space, the orientation, the location, and so on and so forth. And even the zoning requirements, including even how many floors and so on and so forth.
And these are the blueprints paper as it were.
This is the blueprints, as you call them.
Yes.
And having gotten that, then you also need to prepare through a competent structural engineer structural drawings that now indicates the size of the foundation, having assessed, of course, or surveyed the soil by the engineer, of course. They'll design the foundation. Foundation is determined by how deep you need to go because of the type of soil, how big that foundation needs to be, and then the size of the pillars or the columns, how many are supposed to be in that building, and so on and so forth. For the various floors, how thick or how the size of those floors, basically. The things that carry those floors are called beams, which are supported on the columns I've talked about, which are sitting on the foundation, all the way up to the roof. So this is the professional that prepares all these drawings that again have to go to the county for approval. Now, having gotten those two key approvals, that's architectural drawings approval, or the ones you call blueprints. Blueprints because they are printed on blue paper. That's the original blueprints. Then the structural drawings as well. Then now it is very important to know that all constructions will always impact on the environment. So there is a need to now seek approval from the environmental body. That's called the National Environmental Management Authority, where they will also receive these drawings as an attachment together with a report, an environmental assessment report prepared by a competent environmental impact assessment expert, where now this report will indicate the impact of this particular development into the environment, so that from there you get approval or a license, what we call an environmental license, to proceed, which will indicate that if you're going to affect the environment, these are the mitigation measures and so on and so forth. If you're going to dig, if you're going to emit dust, these will be able to mitigate the dust and so on and so forth. All these things are given as conditions there. Now, there are other bodies that are also required to give you approval, depending on where you're doing construction. Once you submit your all your approval documents from other regulators to NCA, we do due diligence before we actually proceed and issue with what we call a compliance certificate, meaning that you've complied with all the requirements in the construction sector to be able to proceed to construction. And for us to give you a compliance certificate, in addition to those documents that you've been given by other regulators, we will now ask you that because now you want to move to construction, you now need to get a contractor who is licensed by National Construction Authority. And this contractor must be qualified to the extent of the work that you want to carry out. So you cannot take a small size contractor to do a big project. We have NCA 1 up to NCA 8. NCA 1 is the biggest, so it can do unlimited project in terms of scope. NCA 8 is limited. NCA 8 can only do up to about 10 million if it's a building project. Anything more than that is like putting a big load on a small vehicle, which may overwhelm it and may not survive. So we're asking developer in this case that you must look for the right contractor based on the category we have issued the license, based on the class. Category is how big or how small. Class is the kind of work. For instance, if you have category 1, which is the biggest contractor, and it's a roadworks contractor, you cannot use category 1 roadworks contractor to do a building project. So you need a contractor who is qualified for buildings. You cannot use, for instance, a mechanical contractor to do a project that is not mechanical in nature. So the idea of category here and class is very important. And during construction, we'll also ensure that we keep paying visits and having to check compliance requirements or compliance levels for which project we gave you. So if, for instance, you submitted contractor A to be the one doing the project, but on the ground you have contractor B, that is non-compliant to start with, because you need to inform if you're changing a contractor. If you said it would be engineer Z, but on site it's engineer Y, that's already non-compliant, unless those two engineers are working together but for contractors, they're always different companies. For engineer, of course, unless the engineer has an individual, but working for the company for where the engineer used for registration is held responsible. He's supposed to take accountability for the project that is being done. So that's how we do it. And those are the requirements for our project to be fully compliant and to ensure that we are doing it in a quality manner.
Now, can the NCA stop somebody from developing an uncontrolled building?
Yes. If at the time of site visits, during our normal routine compliance checks, we come across something that is not compliant with the requirements of the law or the approvals, then we suspend the works. We suspend the works and we ask the developer to comply. Now, failure to heed to our suspension notice, you can actually take a legal action, in which case we will press charges against that particular developer who is defying the suspension orders or notices. And then upon conviction by a court of law, you can either be fined a fine of not more than 1 million, or a maximum of 1 million, or a jail term of not exceeding 3 years, or both, depending on what the judge may find out. So that is the consequence of not complying with the suspension order should we find you to be non-compliant.
Super. Well, thank you very much for coming onto the show.
Thank you.
That was very enlightening. That was super enlightening. Thank you very much, Engineer Maurice Akech. Always a pleasure to have you. Brilliant, brilliant. There you have it. Now you know who to report to, you know what the requirements are, and you're definitely more enlightened as I am. And this, as always, is Property Focus. You only caught this, and next week we've got something very interesting. Stay tuned. My name is Peter Ngigi. Goodbye.